So question 1 reads, with reference to alternative dispute resolutions, explain the term arbitration agreement. Because before I consider this question, I'm going to give you an opportunity to attempt. What do you think is the meaning of arbitration agreement? What is the meaning of arbitration agreement? What is the meaning of arbitration agreement? That is question 1A, Roman 1. Question 1A, Roman 1, meaning of arbitration agreement. What is the meaning of arbitration agreement? Laura says it is an agreement that requires people who sign it to resolve any dispute by binding arbitration rather than in court before a judge. Okay. Wafula says is an agreement between two disputing parties agreeing solve disputes outside court. Okay. Silas says is where dispute is submitted by agreement of the parties to one or more arbitrators who makes binding decision on the dispute. Good. The answers that the three of you have given are not bad. Benita says it is a contract in which two or more parties agree to resolve any disputes that may arise between them through arbitration rather than through litigation in court. She goes further to write, arbitration is a private dispute resolution process where the parties present their case to a neutral third party arbitrator or a panel of arbitrators who will then make binding decision on the matter. So she has defined, she says, is a contract in which two or more parties agree to resolve any dispute that may arise between them through arbitration rather than through litigation in court. So Perita, up to that point, that's the answer. Okay. Anything that you've said after that is true, but is not necessary. You are not required to define arbitration. You are to define arbitration agreement. Arbitration agreement is a contract, and to put it even more accurate, you can say it is a legally binding contract between two or more parties that stipulates that any future dispute arising between them will be resolved through arbitration rather than through court litigation. Okay. So you see, your answers were not far off from the truth. So it is a legally binding contract between two or more parties. So if you are to get into a relationship with you, say business relationship, okay? Or maybe we are partners in a business. So before we begin the business, we enter into an agreement, a legally binding agreement or contract, stipulating that as we begin our contract today, any disputes that will arise from today's henceforth will be resolved through an arbitrator, that is a third party, rather than through court litigation. So the parties agree that in case they have any problem among themselves, they not go to court, but they look for a third party to resolve the dispute. You understand? A legally binding contract or Candace, before I write, can you write what I've just said? Define it. Write down what I've just said. I've defined it. Can you please write down the definition? If you have written it, just refine it. Write down on paper what I've just said. That's how we revise. You try to recall in your memory. That writing also helps you to reinforce what you have heard. So put down the definition in your notebook. It is a legally binding contract between two or more parties, okay? Between two or more parties that stipulates, okay, that any future disputes, any future disagreements or disputes will be resolved through arbitration and not through court litigation. That is the meaning of arbitration agreement. Wafula asks, why only future disputes? I think also current or past disputes or disputes on specific matters can be resolved through arbitration. That's not the question, Wafula. What you are saying may be true, but you are defining an arbitration agreement. It is a contract. If I was to enter into a contract with you regarding, if you are in, say, I gave an example of a business relationship. If you are starting or engaging in a business relationship, then what you are agreeing on today can only affect future disputes. Do you understand the context? So it's, if there are past, if we've been in a relationship with you and there are past disagreements, you see, the disagreements happened before we had an arbitration agreement. All right? Unless we agree with you that the disputes you had in the past, we let us not go to court. Right? But the very definition of an arbitration agreement is just an agreement between two or more parties. You agree in advance that any dispute that you are going to have will not be resolved in a court of law, but through an arbitrator. Do you understand the difference? So arbitration agreements are deliberate agreement between parties who are entering into different kind of relationships, could be business relationships. So you agree in advance. Okay, you agree in advance that in case we may have disagreements, let our disagreements be resolved by a third party. Do you understand? Yes. But we can form the agreement when the dispute rises. Like we have a dispute today, we can enter into a contract to resolve it through. So Wafula, if we have an agreement today, if we have a disagreement today, we do not need a arbitration agreement to resolve it. If both of us have agreed, we are not going to court. We don't need an agreement to that effect. You understand? If we are having a relationship with you and both of us have agreed that let us resolve this matter outside the court, we don't need to do an agreement because we already agreed. Do you understand the difference? There is no point of having an arbitration agreement to resolve a matter that we've already agreed upon. If we already agreed that we are not going to court, then what is the point of having an arbitration agreement? So arbitration agreements are only relevant or only take place when there are no disputes. So you agree in advance that in case there will be any future disputes, we will not go to court. You understand the difference? Wafula says, I think that agreement is the contract. Like we had a case in court with my employer. We decided to resolve it through arbitration where we had a third party. Yeah, there was a previous disagreement. We decided to solve it through arbitration. Did you, in that case, Wafula, enter into an arbitration agreement? You agreed. If parties agree, my point is, if we have agreed that we are not going to court, it is not necessary to have it on paper as an agreement that we are not going to court. Because we are not under aggregation, we are not under any obligation to write it or to go to court. If an agreement can be just verbal. Okay? You understand the difference? You can agree because these are private matters. Okay? You can agree with whether it is an employer or a business partner not to go to court. So the agreement is could be related to past, as you are saying, but it's not necessary to have it in writing that you are not going to court. You can just decide not to move to court and work out your disagreements And you are right, an agreement is the contract. So let's move on to the next part of the question. Outline 6 matters which may not be referred to or determined through arbitration. Outline 6 matters which may not be referred to or be determined through arbitration. What is your take? Wafula says murder case. Murder case. Any other matter? Now, Wafula, the better way to put it, other than saying murder case, a murder case is a murder is a crime. So instead of just saying murder, the best way to write it is to say criminal matter or matters. Criminal matters. You understand? Murder is a crime. So criminal matters which involve actions against the state, they carry potential penalties such as imprisonment, which are generally not subject to arbitration. You understand, Wafula? Criminal matters. It's not just murder. It could be rape and any other crime. Robbery with violence, such matters cannot be referred to arbitration. So the first matter you write, this is Roman 2, matters not referred to arbitration. 1, criminal matters. And I've explained why criminal matters cannot be determined through arbitration. Okay? Silas says guardianship. One says matters relating to violation of human rights. Laura says matters relating to interpretation of the Constitution. Silas says insolvency petitions. Insolvency petitions. Opula says public interest issues. Laura says election disputes. Laura, election disputes are not resolved through arbitration. They are resolved through legal processes within established the court system. If you are old enough, you recall the presidential disputes that have happened in Kenya. Other parliamentary, we've also had disputes. All the disputes must be determined according to the law through the court system, not through arbitration. But if you have specific circumstances relating to elections like internal party disputes, you understand? Some political parties may use arbitration to resolve internal disputes. Because their constitutions may have arbitration as one way to resolve disputes. Perita says employment matters. That is true. Public intellectual property disputes. Laura says matters relating to interpretation of the Constitution. That the matters relating to interpretation, candidates are hard if you've been studying administrative law or administration of law in Kenya. The High Court is a court that has been vested with the jurisdiction of interpreting the Constitution. It cannot be resolved through arbitration. Perita says intellectual property disputes. That is a matter not referred to arbitration. Intellectual property disputes. Intellectual property disputes. Okay? Intellectual property disputes cannot be resolved through arbitration. Intellectual property disputes, or disputes involving, we can say disputes involving intellectual property rights. You understand? Those cannot be resolved through arbitration. Then we have public interest issues. That is true of Wafula. Public interest issues. Public interest issues. Public interest resolving matters of significant public interest, such as environmental protection, such as public health, matters such as consumer rights. Those are examples of public interest issues. Such matters may be excluded from arbitration to ensure that they are resolved in a transparent and accountable manner through a court system. Public interest issues or matters. Penina says criminal matters. That is true. That was our first point. Hanu, public issue matters. Hanu, that is public interest matters or issues. Public interest. Then we have employment matters. Employment matters. Is it true? Someone just told us they resolved an employment matter in court. Who was it? Wafula? Wafula told us that he had a case in court with his employer, and they decided to resolve it through arbitration. Wanja says bankruptcy disputes. Bankruptcy disputes. So that is bankruptcy or insolvency proceedings. Bankruptcy or insolvency proceedings. These are issues that are related to insolvency and bankruptcy, such as the winding up of a company or the distribution of assets among creditors. These are generally handled through specific legal processes and are not suitable for arbitration. Bankruptcy or insolvency proceedings. Okay? Let's analyze any other points here. We have I saw something like guardianship. Guardianship. Someone said guardianship. What was it? Family disputes. Yeah, that's true, Anja. Silas says guardianship, then there is family disputes. The right word there is matrimonial disputes. Matrimonial disputes. Matrimonial disputes. Matters relating to divorce, matters relating to separation, matters relating to child custody, and even maintenance are typically excluded from arbitration because they involve sensitive family issues that require the oversight of a specialized family court. You understand? And the reason why some of these matters cannot be resolved through arbitration, like matrimonial disputes, because some of the matters require specialized attention, and we know arbitrators are not required to be specialized professionals. You understand? We can agree with you to appoint anyone to be our arbitrator to resolve our dispute. That anyone may not have the required skills, knowledge, and training to resolve all disputes. That's why there are certain matters that cannot be resolved through arbitration. And one example is insolvency is not an easy matter. Bankruptcy proceedings can only be heard by the courts, by the judges who are trained to resolve such disputes. You understand? So these are 1, 2, 3, 4, 5. Give me another one, please. Give me another matter. Someone says here, matters relating to violation of human rights. Matters relating to violation. Hanu says matters relating to violation of human rights. Hanu, matters relating to the violation of human rights are not typically referred to arbitration because human rights are fundamental. Human rights are unalienable and are considered to be of public importance. They are not matters to be negotiated or even compromised in private proceedings like arbitration. Furthermore, countries or states have the primary responsibility to protect and promote human rights. So when these rights are violated, it is generally expected that the state institutions, particularly the courts, must handle such matters. So matters relating to violation of human rights cannot be referred to arbitration. Do you understand, Hanu? Wanja says consumer protection cases. Consumer protection cases, Wanja, we argued that under, what was it, public interest issue. That is a public interest issue. That is point number 3 on the board. How many points were we to give? We are to give 6 matters. Please give me the 6th matter. There is someone who mentioned employment disputes. Employment disputes. Employment disputes, candidates, here in Kenya, while some employment disputes can be referred to arbitration, there are certain matters such as unfair termination, matters such as discrimination in employment, matters such as sexual harassment. Such matters are excluded and fall under the jurisdiction of employment and Labor Relations Court. Okay? You understand? There are certain matters relating to employment disputes that may be referred to arbitration. But the examples I've given, like sexual harassment, unfair termination, discrimination, such employment disputes can be referred to arbitration. So these are 6 matters that cannot be referred to arbitration. 1, 2, 3, 4, 5, 6. Is that clear? Part B of this question reads, in relation to the tort of nuisance, differentiate between private nuisance and public nuisance. 4 marks. And as we know, a tort is a civil wrong, and one such civil wrong is nuisance. There are 2 types of nuisance: private nuisance and public nuisance. What is your take on that? Without referring to your notes. Private affects an individual, while public affects a large number or the whole community. That is true. That is true. Differentiate between, this is got to be, differentiate between private and public nuisance. Someone else try? 4 marks are added here. Candidates, how many points or distinctions do you think are needed for you to earn the 4 marks? Or full? What do you think? How many points? Because the examiner is not clear on how many distinctions you have to provide to earn the 4 marks. So what do you do in an exam room? How many distinctions do you give? If you have been taught to distinguish 2 terms like these ones, and you are awarded 4 marks. I'm waiting for you to answer that question. Correct. 2 points are enough for you to earn the 4 marks. So we have public, and candidates, when you have terms to distinguish, please present the differences in a columnar format so that you have public nuisance, private nuisance. It's good to have the distinctions in a columnar format. And why do you think candidates presenting the answers in columns is better than presenting the answers in paragraphs? Why do you think it is desirable to have the answers in columns? Can someone answer me that? One reason is that when you present the answers in columns like this, the way I've demonstrated here, it becomes easier for the one who is marking to see the distinctions. Your answers become marker friendly. Okay, so you can have one column for the basis of the difference, then you have the 2 terms. And one basis for distinguishing terms is just by defining definition. If you define private nuisance and define public nuisance, that definition will bring out one difference. So a private nuisance is an unlawful interference with a person's use or enjoyment of their land or some right. Do you understand? Wafula had mentioned that it affects an individual. But to put it more accurately, Wafula, private nuisance is an unlawful interference. Being a nuisance is to unlawfully interfere with a person's enjoyment of their right. You understand? It's unlawful interference of an individual's enjoyment of right. You understand? Private nuisance, I repeat, is an unlawful interference with a person's enjoyment, okay? Interference of a person's or an individual's enjoyment of some right. So you can be a nuisance to an individual, or you can be a nuisance to the general public. You understand? So nuisance may affect just an individual or a group of individuals, many individuals, or the public. Public nuisance, that is to say, is an act or omission that materially affects the reasonable comfort and convenience of the members of the public. Do you understand? So that is one definition or distinction based on definition. Now, the second distinction can be based on the scope of nuisance. Scope of nuisance. Or let me say scope of impact. Scope of impact. You can distinguish the two by identifying the scope of impact. The scope. Here we have said that the nuisance only affects an individual, whereas the public nuisance affects a class of people or a community as a whole. This one affects an individual. This one affects a class of people or community. For example, if you are playing loud music in your house, you can maybe unlawfully interfere with your immediate neighbors' enjoyment of their right to peaceful environment, or your music can affect the whole community. If it's too loud, it can affect a larger group of individuals in a community. Scope. You understand? So these are two differences. Another distinction can be based on the one who standing Like, let me say standing to sue. Standing to sue. Standing to sue. For private nuisance, only the person with an interest in the affected land, okay, can sue. Only this individual who is affected by this private nuisance can sue. But in public nuisance on the other hand, candidates, public nuisance, an individual can only sue if they have suffered special damage beyond that of the general public. Do you get the difference? We can distinguish private nuisance from public nuisance by looking at the persons who stand to sue, who have a right to sue. Those who have a right to sue. And I've said that in private nuisance, only the person with an interest in the affected land can sue. Whereas in public nuisance, candidates, an individual can only sue if they have suffered special damage beyond that of the general public. Okay? Otherwise, it is the Attorney General, or even, the Attorney General who typically brings action in public nuisance. But if it's an individual who has suffered more damage than the rest of the members of the public, and there is evidence to that effect, then such an individual can sue for matters relating to public nuisance. You are to give 2 candidates, but I'm giving more because you may be required, maybe in your paper, to give 4 distinctions. Another basis for distinction is focus. Focus. The focus. Private nuisance focuses on the interference of an individual's property rights. Okay? Individuals. It focuses on an individual's rights. Okay? Individual's property rights. That is private nuisance. Whereas public nuisance concerns the interference of public rights. It is concerned with the interference of public rights. Focuses on the interference with individual rights, whereas public nuisance concerns with the interference with the public rights and interests. And of course, examples of private nuisance include playing loud music, okay? Loud music, loud noise from a neighbor's property. It could be foul smell. If there is a dog or a cat that has died in your compound and is emitting foul smell, that can constitute nuisance. Okay? Or even noise from a nearby factory, that can constitute. Another example could be just even branches of a tree. Branches of a tree hanging over your neighbor's fence, okay? Damaging property in your neighbor's compound. That is an example of private nuisance. Examples of public nuisance include obstructing the public highway. If you obstruct the road, obstruction, that is an example of public nuisance, right? Obstruction. when you obstruct the users of a road, or polluting a river that is affecting a community. If you pollute a river that is used by many members of the community, that is public nuisance. Carrying out dangerous activities, okay, which poses a risk to the public, that constitutes public nuisance. So these are a few distinctions of private and public nuisance. Do you understand? Is that clear? B Roman 2. Discuss 4 defenses to the tort of nuisance. Defenses to the tort of nuisance. Defenses to the tort of nuisance. If you are accused in a court of law of nuisance, how will you defend yourself? That's what the question is requiring us to answer. What do you think? What do you think, Silas? Laura says inevitable accidents. Wafula says consent, like the person was aware or unaware. All right. Now, one obvious defense is statutory authority. Statutory authority. Statutory authority may be used as a defense to the tort of nuisance. If the alleged nuisance is authorized by a statute or legislation, because that's the meaning of statutory. Statute is an act of parliament or legislation. If there is an act of parliament that gives one the authority to engage in the act, then that can be used as a defense. If the alleged nuisance is authorized by a statute or legislation, it can serve as a defense. However, the defendant must demonstrate that the nuisance is an inevitable consequence of the authorized activity, and that all reasonable precautions were taken to minimize the impact. You understand? That is one defense. Another defense is what we call prescription. 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 That is to mean if the nuisance has been going on for a continuous period of time without any objection from the claimant, then the defendant may acquire what we call a prescriptive right to continue the activity. Prescriptive right. If the defendant has been doing the thing over a long period of time and no one has complained, then when this defendant is taken to court, the defendant can acquire what we call a prescriptive right. And that is a defense. Now, a prescriptive right allows the defendant to continue the activity even if it causes nuisance. Why? Because they would have acquired a legal right to do so through the long usage. So if you have been engaging in an activity that may be considered nuisance and no one has been complaining for a long period of time, say 20 years or so, then you can obtain a prescriptive right to continue doing the activity, and that right acts as your defense, so that if anyone runs to court to accuse you of nuisance, you can now use it as a defense, because such defense essentially legalizes the nuisance due to its long-standing existence. You understand? That's what we mean by prescription. That's a defense to the tort of nuisance. All right? Another defense is what we call coming to the nuisance. Coming to the nuisance. Coming to the nuisance. What does that mean? Now, if the claimant, and here the claimant is the one who accuses another for nuisance. If the claimant knowingly moved into an area where the nuisance already existed, they may have a weaker claim in a court of law. If you moved into an area and there is a lot of noise, knowing there is noise, and you accuse the one who is producing the noise, you came to the nuisance. The defendant can use that as a defense, that the claimant came to the nuisance. But you have to understand that the coming to nuisance defense is not absolute. It is not what? Absolute. That is to mean that the court will consider the nature and the extent of the nuisance, as well as the reasonableness of the defendant's conduct. It is not guaranteed that the court will grant you this defense. It's not absolute. But you understand? Coming to the nuisance. The fourth defense is what we call public benefit. Public benefit. Public benefit. If candidates, in some cases, the defendant may argue that the activity causing the nuisance provides a significant public benefit that outweighs the harm caused by the claimant. You understand? Public benefit. And such defense is often used in cases involving infrastructure projects or essential services. But here, just like the coming to the defense, the court will also carefully balance the public benefit against the individual harm suffered. You understand? Yes. So these are four defenses to the tort of nuisance: statutory authority, prescription, coming to the nuisance, public benefit. So candidates, when answering this question, you may not necessarily have to use the words I'm using. You can paraphrase these words, just like Wafula has been doing and the rest of you. Okay? We've answered question 1. Bye-bye.